Good afternoon. Welcome to our program today entitled An Independent Contractor, an Employee, and Their Attorney Walk into a Bar, Why This Is No Joke for a Nonprofit. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. And this program, as many of you know, is part of the monthly series of programs that we do here in Venable's new D.C. offices on a wide variety of different nonprofit legal issues. We have a packed room here of over 100 people joining us for lunch in our Washington, D.C. offices today. And we have over 400 people joining us on the webinar across the country today. So one of our highest numbers of registrants, certainly since we started doing these programs 6 years ago, and we're very pleased and gratified and hope we don't disappoint here today. No pressure, speakers. All of these programs, as you also may know, are recorded and now with a live video stream, as those of you in the webinar are seeing. And we put all of these on our nonprofit YouTube channel. Tomorrow, all of you will receive an email that contains a link to the recording of today's program, along with the PowerPoint slides and all of the related handout materials. Feel free to forward that on to colleagues or others who might benefit from that. And the link to our library of all of our recorded webinars for the last 6 years can be found on the final slide of today's presentation. A few housekeeping notes. For those of you from the trade and professional association community, these programs are eligible for CAE continuing education credit. For the first time in 6 years, we are taking the summer off. We will not have programs in July or August. They have traditionally been lower attended than other programs, and we could use a little break as well. But we will resume with a very strong schedule starting in September, and we'll have those announced as soon as those are finalized. In terms of handouts, those of you in the room have a handout booklet that contains a copy of the PowerPoint slides of today's program, along with some very helpful articles that I hope you will take a look at, and full bios of our speakers. I'm going to introduce them in a minute, but I will not do them any justice, so please take a look at their bios. Those of you in the webinar received a link to the PowerPoint slides as part of your confirmation email today. In terms of questions, those of you in the room, feel free to ask questions throughout the program. Raise your hand and please wait for the microphone to come to you so everyone on the webinar can hear your questions. Those on the webinar, please pose your questions to me using the chat feature of the webinar software. Now, our speakers, we have three of my colleagues here at Venable. All three are very accomplished, successful, and talented employment lawyers. To my immediate left is Doug Mishkin, partner. To his left is Nick Ryder, associate. And make sure I get the pronunciation of, is it correct? Carl, sorry. Carl Mazanek is an associate. Both Carl and Doug are resident in our D.C. office. Nick works out of our New York office. All three work very regularly with our nonprofit clients, both in terms of employment counseling as well as litigation and other claims that we have to deal with sometimes in this space. So all three have extensive experience working with the issues involving independent contractors and employees that we're going to be dealing with today. They're bringing a wealth of practical experience as well, things that we've seen over the years working with hundreds and hundreds of our nonprofit clients in this area, kind of seeing things that work, seeing things that are typical pitfalls, common traps. And anytime Michigan is involved in one of our programs, you know there's going to be great stories and examples and case studies and, of course, a lot of jokes. So be prepared and apologize in advance for anyone who we may offend through this process. But please do take a look at their full bios in today's handout presentations. So without any further ado, I'm going to turn it over to Doug to get us started. Doug.
So an independent contractor, an employee, and a lawyer walk into a bar. The question is, what's the difference between the independent contractor and the employee? And the answer is, if you can't tell the difference, it's happy hour for the lawyer. These issues are no joke. It seems like they've been around for forever, but why are they more important now than ever? Well, we know the basics. In many situations, for many reasons, usually you will want someone to be your contractor, not your employee. But when it comes to the battle of who's a contractor or an employee, let's be clear. The playing field is tilted. It's tilted heavily in favor of the result being that a worker who's working for you is an employee. Generally, a worker working for you is an employee until proven otherwise. So this means we've got two threads that you will hear throughout this brief presentation. More people who do work for you are employees than you think. Okay? More people who do work for you are employees than you think. And secondly, what that means is more of you are employers than you think in more situations than you would have thought. And yes, the concept of joint employment plays into this. More about that a little later. During our brief time together, here's what we're going to do. Nick's going to talk about so what, or namely, why are we here? Why do you care? Why do we care? What are the consequences of getting these issues wrong? Then, what is it we're talking about? Carl's going to give you the factors that distinguish contractors from employees. Then Nick's going to talk about how to get it right, namely, what are the do's and don'ts for documenting and implementing the independent contractor relationship? And then I will do cleanup. How can you get it wrong? What can you do and what can't you do to fix these problems? With that, Nick.
Thanks, Doug. Good afternoon, everybody. Can everybody hear me in the back okay? Yep. So as Doug was saying, I'm going to talk about, and the title of our program, why this issue is no joke for nonprofits. And the real big ticket item on here, it's why it's our first one up on the slide, is overtime wages. I assume a lot of the folks in the room today and listening online are working at a nonprofit in some type of HR capacity and are familiar with the Federal Fair Labor Standards Act, where employees are entitled to 1.5 times their regular rate of pay for their work hours beyond 40 hours in a week. Independent contractors are not entitled to those same overtime wages. And it's no wonder then that many nonprofits and even sometimes the individuals, they'll prefer to engage an individual on an independent contractor basis, because then the nonprofit doesn't have to pay overtime wages. It can save money there. And it also can avoid the administrative burden of having to keep track of the individual's work hours. But that's only the case if the classification of the independent contractor is correct. Everything kind of falls apart if there's a misclassification issue. And if so, the individual can later sue for overtime wages. He or she can later sue for minimum wages, too, if that minimum threshold isn't met. And the statute of limitations under the federal law I mentioned, that goes back 3 years for a willful or a reckless violation. But in a lot of states, there's longer limitations period. Like my home state, New York, it's a 6-year statute of limitations. And the reason this is so important, the so what for our program, if your nonprofit loses the misclassification issue, that is, if at the early stage of a dispute, you can't convince the Department of Labor or a judge, if there's a court case, that the classification is correct, then your nonprofit might be in a very difficult position to refute the individual's allegations of his or her work hours. You know, you might be thinking, oh, well, our nonprofit has engaged this independent contractor and he or she's working about 30, maybe 40 hours a week. But then when the relationship ends and the individual might decide to file a claim, he or she suddenly has been working late nights, weekends on a routine basis, and they're claiming a 60 or 70-hour work week to meet these onerous deadlines for projects, and your nonprofit says, no way, that wasn't the case at all. He or she's making it up, but you don't have time records, and you don't have time records because your nonprofit classified the individual as an independent contractor. You didn't think that they were necessary, and in a lot of states, New York, for example, there's a rebuttable presumption that whatever the individual is claiming is true if the putative employer can't produce time records. And that makes it very difficult to defend against those types of overtime wages lawsuits. That's why that classification dispute, that early legal issue in that type of claim, it's so critical, and that's why we're talking about it today.
And Nick, just to clarify, for instance, when you say New York's laws impose certain protections greater than certain other states, we're talking about the state in which the employee is located, not necessarily where the employer is based. So I know a lot of folks in the room and on the webinar may, be based, for instance, in the Washington, D.C. area, but have, a small office in New York, or a remote employee in New York, or one in California.
Right.
So you want to speak for a bit just about the general applicability of the various state laws?
Yeah, different jurisdictions have different requirements and factors for what law is going to control, but typically it's going to be the state in which services are performed. There are some limited circumstances where you're going to see it's the state in which services are directed, but typically if you have an employee based in a given state, that given state's laws are going to control. Sometimes you'll see, if an employee could be based in Idaho, but they're calling people exclusively in New York to raise money for your organization, there could be an argument that the New York law would be applied because the services were directed at New York State, but in most cases it's going to be the home state for where the employee is actually performing the services. Just a note about the potential damages, too, for the overtime wage claims, because a lot of states have relatively draconian liquidated damages provisions. It's another reason why this is so important. In New York, again, my home state, there's 100% liquidated damages for an overtime wage claim under New York labor law. The successful plaintiff can also seek another 100% liquidated damages under the Federal Fair Labor Standards Act. And what that means for your nonprofit is that every dollar of overtime wages that might be owed to a misclassified worker, that could end up being $3 in overtime wages by the time that the lawsuit is over. So overtime wages are the big ticket items, but I also want to briefly run through some of the other areas of financial exposure for misclassification issues. There's workers' compensation issues. You could have your nonprofit subject to penalties for failing to place a misclassified worker on your workers' comp policy. There could also be damages if there was a workplace injury to the misclassified worker and he or she did not receive workers' comp benefits. You have unemployment insurance issues, and this is, I think my colleagues are going to talk about this a little bit later, but this is one of the ways we see most routinely that the misclassification issue kind of rears its head, is that the business relationship ends and the misclassified worker says, oh, now I want unemployment benefits. I'll go file a claim with my Department of Labor office and under a theory that I was misclassified. You could have payroll tax penalties, especially in the last couple of years. State and federal governments have not been shy about sending a demand letter for documents, starting to conduct an investigation to try to recoup some unpaid payroll taxes under a theory that an organization's independent contractors have been misclassified and there should have been payroll taxes paid on that compensation to the independent contractors. And you can also have benefit plan violations. Depending upon the plan rules for your organization's particular retirement plans or maybe your health insurance benefit plans, you could have a misclassified worker later claim that he or she should have been entitled to health or retirement benefits because they were really an employee. The last little bullet point under the damages section here, the I-9 violations. Probably most people in the room and listening online are familiar with an I-9 form. It's the form, the federal form that establishes an individual's authorization to work in the United States. Employers are required to have those forms for every employee, not independent contractors, for every employee for at least 3 years from the date of hire or for 1 year after the end of the employment relationship, whichever period is longer. And if there's a misclassification, you're not, again, it's like the time records for overtime wages. You're not going to have the Form I-9 for someone you thought was an independent contractor. But if there's a misclassification, the penalties for not having an I-9 for that person can range from $110 to $1,100 per violation. And the stakes for all of these areas of financial risk that I just mentioned, they're particularly high because, yeah, they could be pursued by an individual, but they can also be pursued for tens, hundreds, thousands of individuals on either a class action basis or as part of a large-scale government audit. And if you think about a class action lawsuit where every single independent contractor that your nonprofit engaged for, say, the last 6 years could potentially join the suit as a plaintiff and seek overtime wages or the other damages I just mentioned, That single plaintiff lawsuit could be very costly, hundreds of thousands of dollars, but a class action lawsuit could be devastating to your nonprofit's operation budget, obviously. And just finally, a word about anti-discrimination lawsuits. Anti-discrimination laws like Title VII of the Civil Rights Act, the Americans with Disabilities Act, those laws protect employees, but they don't protect independent contractors. So when your organization is severing the relationship with an independent contractor and there's maybe some type of allegation of discrimination from the individual, you always want to consider, well, is our classification sound? Because if it isn't, and you're going to hear some real-life case examples later from Doug and Carl, you could have a situation where that independent contractor later sues under these anti-discrimination law statutes, claiming that he or she was misclassified. Okay, so some common misclassification problems for nonprofits before I turn it over to Carl here for some hypothetical examples. And these are things that we're seeing with our nonprofit clients that come to us asking questions. Number one, up on the slide here, is an over-reliance upon the representations within an independent contractor agreement. Should your organization have a contract where the contractor promises and acknowledges that he or she is an independent contractor and not an employee? Yes, absolutely. But is that enough to convince the Department of Labor or a judge that the classification is correct? No, absolutely not. And as you're going to hear throughout this program, no single factor is dispositive. And we have a lot of clients that come to us and say, oh, I don't need to worry about classification issues. We have an agreement. They promised that they're an independent contractor. That's not going to carry the day in court. They're going to be permitted to later backtrack on that agreement and pursue some type of damages against your organization under a misclassification theory. Point number two here on the slide, there's a commonly held myth or believed myth that short-term employees can automatically be independent contractors. That's not true. If you employ someone for a day even, they will be subject to the same factors that we're going to talk about throughout this program. Now, your potential risk there might be extremely low, right? They're just employed for a day. But some nonprofits might employ individuals on a seasonal basis, for example, maybe for a 10-week period throughout the summer. Those individuals should be subject to the same analysis for whether there's a proper classification. Point number three on this slide, I'm obviously we're all going to say a lot of things during today's program. If there's something that you star or you really remember and resonate with you today, I hope it's this. If there's an overlap between the independent contractor duties and your employees' duties, that's a huge red flag for any investigator or for a judge. It's usually one of the biggest things that will undermine the defense that I'm trying to put on to defend a client against a misclassification allegation. Even if my client checks all the other boxes even if my client checks all the other boxes for the proper classification, if the DOL auditor sees that you have your employees doing A, B, and C on a day-to-day basis, and your independent contractors doing also A, B, and C, or even just A and B on a day-to-day basis, the Department of Labor is going to say, well, why the inconsistent application of your classification theory? Why are you treating one group of individuals different than the other? And it'll usually be too much to avoid some type of adverse finding. Number four here, a note about joint employer relationships. A lot of nonprofits typically will engage a company to perform some type of services, and that company that's engaged, they employ employees. Depending upon the level of direction and control that your nonprofit exerts over the company's employees, your nonprofit could be a joint employer with those employees. Just some examples. Ask yourselves, can your nonprofit tell the company's employees when they need to show up for work? Does your nonprofit give the company's employees maybe a shirt or a uniform with the nonprofit logo on it? Or could your nonprofit get one of those company's employees fired if they did something wrong or disciplined? Those are the questions that a court or a Department of Labor investigator will ask to try to find if there's a joint employer relationship.
And just to point out, we're not necessarily talking about a situation where it's all of the employees, like, for instance, in the model of an association management company where typically the board of a nonprofit organization will hire a management company to provide all of the staffing and staffing services for the organization. That is a potential situation, but there's also situations where the nonprofit has its own employees, but then it's bringing in a firm, a consulting firm, PR firm, lobbying firm, you name it, conference support, where the nonprofit's own employees are having, or maybe even the board, are having a lot of direct kind of supervision and oversight over the employees of that other contractor that's hired. And all of these are situations that you have to consider for this purpose.
Yeah, absolutely. Another common problem a lot of our clients say to us is they say, well, why do we have this issue? We gave the individual a choice. This is the permitting the individual to classify the relationship bullet point. We gave the individual a choice. They told us that they wanted to be treated as an independent contractor. Well, that's not going to be a successful defense later on. And you might have the situation where you say, hey, to the individual, do you want to be paid on a W-2 or do you want to be paid on a 1099? And the individual, ever mindful of how much of their paycheck goes to Uncle Sam, says, oh, I'd love to be paid on a 1099. But that's not waiving their rights. That's not going to bar them from later asserting a claim under a misclassification theory. Another common problem area for nonprofits, providing equipment and training to independent contractors. That's really one of the hallmarks of a traditional employment relationship. The example, and it's a simple example, but intentionally so, the example I use for a lot of our clients is if you are a homeowner and you hire someone to come paint your house, you don't train the painter on how to paint a house, and you don't probably give the painter brushes and ladders and paint buckets. You expect that the painter knows how to paint the house and has his or her own equipment. That's the same analysis that your nonprofit should be thinking about when you engage an individual on an independent contractor basis. And I always tell clients to keep that in mind when they're doing things like providing an independent contractor with a nonprofit associated email account, or maybe providing the independent contractor with business cards with the nonprofit's name or logo. Those are questions that the Department of Labor will ask and will weigh in favor of a misclassification finding.
Nick, before we move on, there's a question from the webinar, but also first I wanted to pose a question to you. Just explain to everyone, so if a situation is determined, if there's a situation, it is determined that the nonprofit is indeed a joint employer over, say some contractor's employees, what does that mean for the nonprofit, and what does that mean in terms of what it should be doing proactively and preemptively?
So it's a great question. It essentially means that you're standing in the shoes of the company that your nonprofit has engaged in terms of their employment relationship with those employees. And if that means if there's some type of, say, for example, a discrimination issue between the company that's been engaged and their employees, your nonprofit could be named as a co-defendant. And if that company were to go belly up or not be able to satisfy a judgment, the plaintiff could theoretically come after the nonprofit and the nonprofit's funds to try to satisfy a judgment. There should be, we don't have probably enough time to go through all the things you should do to safeguard yourselves against joint employer issues. That could be another program, but indemnification in your engagement agreements with a company like that is a great thing, as well as representations about a lack of direction or control over their staff.
Thank you. And I know we're going to get into this more later, but one of the things that you guys should all be thinking about based on some of the things that Nick just said is that if you have a situation where you want someone to be an independent contractor, of course, the fact that they're willing to be is not very relevant to the analysis. But if you want them legally to be deemed to be an independent contractor, there are a lot of things that you can do preemptively, proactively through, especially through that initial written agreement with them and the kinds of things that Nick is talking about, things to do, things to not do. And I'm not just talking about putting language in there that says that this person is an independent contractor, not an employee. I'm talking about the real structural, functional issues about how the relationship is structured. We deal with this all of the time, and you can really strengthen your hand if you do that smartly at the outset. I have a question from the webinar that says, if you have an arrangement for temporary help, for instance, accounting temps, which is obviously extremely common in the nonprofit community, you likely, this is presumably hiring a firm that is sending over some accounting temps or outsourced accounting support or whatever the case may be. And you likely tell those individuals when to come in, you assign them tasks, what you want them to do. You can dismiss them if you don't like their performance. Does this create a joint employer relationship for an employer that hired the firm?
So the answer is it could. I'm sorry we can't give more of a definite answer than that. In fact, the state of the joint employer doctrine could not be more in flux than it ever was now. You have in one case the National Labor Relations Board position that's under appeal before the D.C. Circuit. That appeal is still pending. You had just a couple days ago the current administration's Department of Labor rescind their Obama-era guidance on the joint employer doctrine. So it's in a huge state of flux. But in that specific example, yes, some of those things, telling them when to show up to work, being able to get employees fired, that could weigh in favor of a joint employer relationship. But usually the biggest factor is the direction and control factor. And so long as you're not really directing and controlling the staff about how they're going to actually perform their accounting functions and providing them training on that and the like, that will be a big factor that will weigh against a joint employer relationship.
We'll keep moving. We'll get into some of these specifics further down.
Just two quick points for more common problem areas we see for misclassification issues with nonprofits. The second to last bullet point, mandatory work hours, and we were just touching upon it with a question from the web folks, actually. Requiring an individual to show up 9 to 5, the same work schedule as your employees, that will weigh in favor of a misclassification finding. It doesn't mean you can't tell your independent contractors when they need to be available for maybe phone calls or meetings. You can still exert some control over their schedule. They need to be accessible, right? But giving them a rigid work schedule like an employee, that can support misclassification. And lastly, non-competition promises. That's more appropriate for an employment relationship. Courts and the Department of Labor, they're going to want to see that the independent contractor, after the end of the business relationship with the nonprofit, is permitted to go out into the marketplace and continue to earn his or her living after the engagement ends. But, and I'm going to touch upon this later in the program, that does not mean that you shouldn't have safeguards in your independent contractor agreement that prevent the independent contractor from using your organization's confidential information after the end of the engagement. And that's it for me for now. I'm going to be back later. But right now, I'm going to turn it over to Carl to give you walk you through some hypothetical examples.
Good afternoon, everybody. Can everybody hear me okay? All right, so I am going to go through some of the factors, the legal standards to... How's that? Is that better? So I'm going to go through the legal standards to make a determination if somebody's an employee or a contractor. But before we get to that, we thought it would be fun to present some of this information in the way that most of America gets their critical information, and that is through a game show. So I'm your entertainment for today. I'm your host. Welcome to our show. It's very easy to play. I'm going to tell you about a recent case, and you guys just get to guess, employee or contractor. So let's play. Behind door number 1, we have some exotic dancers who got tired of some long shifts. They sued for overtime. The clubs said, no, you are independent contractors. You're not employees. We're not going to pay you for overtime. So they fought it out, and it went to the Fourth Circuit Court of Appeals. And these are some of the factors that the court considered. All right, so the dancers, first off, of course, they signed an agreement that said you are definitely independent contractors. Second, the clubs didn't pay the dancers at all. The dancers were compensated solely through the customers, through tips and fees. Fees, I might add, which were set entirely by the clubs. The dancers couldn't charge above or below those fees. And then the clubs also controlled various aspects of the relationship. They set the schedules, the shifts. They set the physical space of the actual club, you know, the hours of operation, the lighting, the music, that sort of thing. And then they also controlled the performances to a certain extent. So they controlled how the dancers looked, what they could wear, their behavior, who could visit them while they were working, those sorts of things. And so, by show of hands, who believes these were employees? All right. Who believes that they were contractors, independent contractors? Oh, I should add, no cheating. No looking at the next slide over that has the answer. I should probably say that up front. No cheating. But yes, you are correct. They were, in fact, employees. They were misclassified. And so the clubs were liable for not only overtime, but in fact some liquidated damages in this case for what the court deemed was a willful violation, at least partially so. And so,
Brian in the AV room, be sure to pan the audience next time so everyone can see how many people guessed right or wrong.
All right. Yes.
Well, just wait for the mic.
Right. Sorry. You mentioned liquidated damages, and those aren't supposed to be punitive, right? So how do they, is that just figured out on like what their wages would have been if they would have been an employee, or how do you come to that calculation?
So liquidated damages, it'll depend on the law. I think in this case it was double the damages because it was an FLSA claim, right? So it was double the hours worked in this case. And that was determined by the court because there was some prior history here. There were some prior lawsuits. And so the employer was put on notice that they might have not classified them correctly. There was a whole issue of when did they go to see an attorney, how they could rely on the advice that the attorney gave them, and that's how you calculated the hours. In fact, in this case, it was up until the time they went to see the attorney was the liquidated portion. After that, they relied on the attorney's advice, and those hours forward were not liquidated damages because they had a defense, good faith effort that they relied on their counsel's advice. By the way, if you're wondering why the court came out one way or another here, I'm not going to tell you, but stay tuned. Doug is going to come back later, and he's going to go into the analysis here, which factors the court considered more important than others. So stay tuned. I'm just here to set out the facts and build the suspense. So.
And I know that we are getting flooded with questions on the webinar, and a lot of them are fact-specific about what sort of factors carry more or less weight in the analysis, and we're going to get to all of that.
We're going to get to all of that. Doug's going to cover all of that for each one of these cases. So hold on. Behind door number 2, we have some yoga instructors. These were non-staff instructors that were terminated. They applied for unemployment, and the studio again said, no, you were independent contractors. You were not employees, so we're not going to pay for the unemployment contributions. They fought it out, and after years of litigation, this went to the New York Court of Appeals, which considered these facts amongst others. But in this case, the studio, not the instructors, set the fees, and they charged the customers directly. The instructors could choose to be paid hourly, and most, I think, were paid hourly, but they also had the choice to be paid a percentage of all the total fees collected. However, they were only paid if a certain number of students signed up and actually attended the classes. And then, again, the studio had control over the physical space. They set the hours of operation, the actual physical space where the yoga was performed. However, unlike the previous case, the instructors here actually set their own schedules because they signed up for the shifts. They signed up for particular classes and when they were taught. And in addition to that, the instructors actually worked at other studios, and they could tell their students, hey, I'm doing a class at the studio across the street. Come see me on this day. So, again, without cheating, how many of you think, by a show of hands, that these were employees? Independent contractors? All right, fair. You guys are right. Independent contractors it is. They were classified correctly in this case. All right. Door number 3, we have some orchestra musicians who wanted to unionize. The orchestra said, you don't have a right to unionize. You're not employees. You're independent contractors. So they contested the union's petition. It went to the D.C. Circuit Court of Appeals, which looked at these factors amongst a few others. And they said these musicians were highly skilled, right? They signed up for usually 1 to 4 concerts every year, and they were paid per concert or per rehearsal, with the exception of if it went beyond a certain amount of time, they'd be paid for every 15 minutes that it went over. Right. But they, again, had the right to go and work for other orchestras. They had other jobs, and they didn't have to sign up for all of the programs. However, the orchestra had very strict guidelines, and it required compliance with everything from a dress code to etiquette standards while you were on stage, your posture, your conversations you could have while you were on stage, and then, of course, the performance itself. Right. The conductor controlled everything from the pitch to the volume, the music itself. And so, let's see what you guys think. Employees? Contractors? Good. I'm glad I finally got a pretty good split on this one. This was an interesting case. Employees, at least according to the DC Circuit, and definitely stay tuned. Doug's going to cover why this is an interesting case, why it's I'm not surprised that there was more of a split on this one. All right. Last example for me. We have a freelance writer, a blogger, worked for a magazine called The Nation, and then his contract expired. He applied for unemployment, and of course, the magazine said, you're not an employee, you're an independent contractor, so we're not going to pay contributions for your unemployment. It went to court, and the court looked at these factors. The writer was well-established, highly skilled. He signed a year-long contract, all right, and they paid him monthly on a 1099, but they paid him a monthly salary. But he worked from home. He used his own laptop. He set his own hours, and by and large, he picked the content of his stories, right? They didn't edit the stories before he posted them. Sometimes they took them down. Sometimes they prevented him from writing on a particular topic. But for the most part, he picked the stories themselves. And he had the right to, again, work for other magazines. And in this case, he, in fact, worked for a direct competitor of the magazine in question. So, last time, independent contractors, employees, you guys are so smart. Independent contractor, he was definitely classified correctly in this case. Now, I want to take a note to say here that I realize that most of you probably don't have exotic dancers and yoga instructors on your payroll. I get that. That simply means that you just have to work a little bit harder to get sued, and then you too can be part of my presentation. But no, all kidding aside, we picked these cases for a reason. The facts, the important facts, the analysis that Doug's going to go into, all of that applies just as much to nonprofits as it does to yoga studios, right? And so with that in mind, I'm going to jump into the actual law, the test here. And the first thing you need to know is there is no one test. There are multiple tests. They all have multiple factors. And the test that's going to apply in the particular circumstance is going to depend on the jurisdiction, also the type of law at issue, right? Is it a tax law issue? Is it a wage and hour issue? Is it a state unemployment issue, et cetera? And so there are various tests, and I don't want to get bogged down in what test applies when. I want to show you the factors and the common themes that permeate across all of these tests. So
before you get into it, one thing to keep in mind, this is the reason why we have record attendance at this program, because this area is so damn complicated and shifting and different depending on the different circumstances. There is a lot to grasp here, like Carl said, because you deal with this from sometimes a tax law perspective, sometimes a federal or state Department of Labor perspective, sometimes from an unemployment compensation perspective, and the analysis is going to be a bit different. But I promise you, at the end, you will walk away with some general guidance on generally, if you want someone to be an independent contractor, there are certain things that you can do in structuring a relationship and managing and overseeing the relationship to be sure that you're strengthening your argument in that regard. And at the end, that's probably what you want to walk away with the most. So try not to get too overwhelmed by all of this, but you do need to know the background.
And that's absolutely right. I picked this test first not to overwhelm you, but to drive home the point of how complicated, how fact-intensive this inquiry is, there are a lot of relevant factors. And two, not one of these factors is dispositive, all right? It's going to depend on the circumstances. Sometimes some of these factors may not apply. Sometimes they may be more important than others, depending on the facts. And third, I like this slide because I think it's a useful cheat sheet. It's a good reference tool to go back and kind of check off when you're analyzing a particular worker or a particular employee. But that said, I'm going to go and move on to the common themes that I referenced. One of the biggest themes that I think is evident across every single test for employee is the degree of control that you as an organization have over a particular worker, whether that's behavioral control, whether it's financial control. The more control that you have over a worker, the more likely they're going to be classified an employee. So in terms of behavioral control, the how, when, and where is the work done? As Nick's already touched on this, where? Do you require them to come to your offices? Can they work from home? Do you not specify? Do you not care? The when. Do you set their schedule? Or can they do this at their own time? The how. Do you set particular procedures, particular methods on how the work's going to be done? Do you micromanage? And what goes into that is also the tools and equipment. Do they bring their own tools? Do they bring their own personnel if they need people to help do the project? Or do you provide those tools? Do you provide that personnel? If you do, they're more likely to be an employee. And whereas if they bring their own tools, their own people, they're more likely to be an independent contractor. And again, not any one of these factors is not a deal breaker. It's all totality of the circumstances test. They all consider all of the relevant factors and then decide based on everything. And then lastly, the training. Do you train this worker? If you do, like Nick said earlier, they're more likely going to be an employee because traditionally, at least, independent contractors are supposed to be hired for their experience, right? You're not going to tell them how to do their job. You're not going to teach them how to paint the house or how to mow your lawn, right? They already come with that know-how.
And just to interrupt, Carl, first off, it doesn't mean that you're not going to be training a contractor on your own systems or your own organization's unique culture or operations. It doesn't mean you can't do that. What we're talking about more is kind of basic background fundamental training, helping someone to do basic accounting or whatever the case may be. So keep that in mind. And Carl, or for any of our panelists, I'm sure a lot of our attendees are thinking, well, does this only apply if we're dealing with an individual who's just working as a solo individual and coming to us as an independent contractor and we're contracting with them in their individual capacity? Or does this also apply, or how does it differently apply if we're dealing with a company that has, maybe it's a single company that someone incorporates their own LLC as a single member, or maybe it's a big firm that they're bringing in to provide outsourced accounting or PR or lobbying or whatever other services they might be providing. Is the basic analysis the same regardless of whether it's an individual or a corporate entity?
Doug, you want to take this one?
Sure. If we're talking about a contract with an outside entity that's providing bodies to do a job, the likelihood is that those bodies are employees of the outside entity. And then the question is, what's the nature of your relationship with them? Are you then jointly employing them? So we don't really get to the independent contractor part of the question unless somehow or another they're all coming to you as independent contractors. But the likelihood is they're coming to you as employees of the entity with which you've contracted, and then the question is, are you jointly employing them?
And that's exactly the answer that I was looking for. That it doesn't mean that you don't have to worry about it. I've heard many clients say to me over the years, well, the person who we're worried about, whether they're an independent contractor, they decided to go form their own LLC, so now we don't have to worry about that issue anymore. And obviously that in and of itself is not going to change the analysis. But Doug is right. I know all of you are thinking of many situations where you are hiring a company that does this for a living and has its own employees. You still have to deal with these issues, but from the joint employer perspective, not from this perspective.
So control can also be financial, and one of the main factors here is how is the worker compensated? In an ideal setting, an independent contractor is going to be paid on some sort of flat fee for the completion of a project, right? You pay a lawn mow company $300 to take care of the lawn. That also gives them some opportunity for profit. If they complete it faster, if they cut their expenses, they can make more, or vice versa. That's the idea anyways. Now, this doesn't mean that you can't have an independent contractor paid on a salary basis. As we saw with the blogger scenario, that writer was paid on salary basis, and the court deemed him an independent contractor. It just means if you do that, pay attention to that relationship, look at and see how these other factors come out. And the same is with benefits and expenses of reimbursement. In an ideal world, an independent contractor is not going to get benefits from the organization, wouldn't have their expenses reimbursed. But again, it's not a deal breaker if you reimburse an independent contractor's expenses. And then lastly, you have some investment in the tools and the equipment and materials. Independent contractors generally have some sort of investment. It's an indicator really that they're working for themselves. They've invested in their own business, which brings me to my next slide and ties well in with the exclusivity of the relationship. Right? So most independent contractors have the right to work for other companies. They have the right to work for other organizations. And in an ideal world, you as an organization wouldn't care that they work for other companies because traditionally independent contractors have done work that isn't an integral part of your business. So another way to say that is they generally have not or should not do work that your regular employees do for you on a day-to-day business. They perform some other tangential service or perform some piecemeal project. And this is one of the main factors I think Nick already covered a little bit in his initial slides. If you have some crossover between employees and independent contractors, that's a big red flag. And the skill I already touched on a little bit. Independent contractors tend to be more highly skilled. Traditionally, you bring them in for their expertise, whereas you train your own employees. And one more thing on the permanence of the relationship. Again, the longer you have the relationship, if it's a continuing relationship from year to year, the more it's going to start looking like an employee, whereas if you have somebody come in for just a duration of a project. As far as the written agreements are concerned, yes, you do want to take a look at what the agreement says, but as Nick has already emphasized, and I can't emphasize enough, just because you call somebody an independent contractor, regardless of if they want to be classified as an independent contractor, if they sign the contract, it's not going to make them an independent contractor without these other factors coming in. All right, I have one last note here, which is on various state tests. I've already told you that there is no one test that governs this standard, that governs the determination of an employee or an independent contractor. States are not bound by the 20-factor IRS test that I showed you, or by any federal standard for that matter. They can have their own tests, and those tests can be more restrictive. As Nick mentioned, New York, Maryland also has a presumption where the worker is considered to be an employee. And if you want to establish an independent contractor relationship, you have to overcome that presumption by looking at, for example, these three big factors, all of which we've already talked about, right? The degree of control over the employee, whether their work is an integral part of your business or whether it's outside the usual course of your business, whether the worker's working for themselves, right? If they're working for other companies, whether somebody mentioned earlier, whether they've established their own corporate entity, they have their own employment identification number, those sorts of factors. So at this point, I'm going to...
Carl, just to clarify, we had a couple questions just now about that. So that is a positive factor if you're contracting with a corporate entity as opposed to just an individual in their personal capacity, but it's not a determinative factor that saves you in the analysis.
Absolutely. Yeah, all of these factors are just piecemeal. You look at the 20 and 30 factors and you kind of determine based on the facts which is more important. So it is a plus, but it's by no means determinative.
And we also asked, some people asked for some clarification on your comment about in a situation where, say, a larger company that has its own multiple employees is brought in, you were saying in that situation, depending on the nature of the relationship, the nonprofit could be held to be a joint employer, but we generally would not be concerned about the risk of individual employees being deemed to be, of that company being deemed to be independent contractors of the nonprofit. Is that correct?
Yeah, I think that's right. I mean, it's always going to be fact specific, but generally the notion of you've brought in 25 people to have a project done and you've contracted with an entity that employs them, the notion that that entity is going to say, well, they're all independent contractors to me, and therefore you can make the argument that they are to you. I don't think that's the likely scenario.
When we have seen I've seen many situations where, say, one employee of a firm that's brought in to provide services ends up working, full time for the nonprofit, day in and day out, goes on for a long time. The nonprofit is really controlling every aspect of that person's operations. There is a potential scenario where that individual could potentially be deemed to be an employee of the nonprofit.
Absolutely.
Even though they work for a larger company with multiple employees.
Right. Well, certainly as jointly employed by the nonprofit. That's the scenario we ought to be focused on and worried about.
All right, thanks.
And this is a perfect time for me to pass the baton back to Nick, who's going to tell you about some of the do's and don'ts in writing independent contractor agreements.
So thanks, Carl. We love the questions. Please keep them coming. They have pushed us a little bit back along our program. And all that means is, and we still want you to keep asking questions. All that means is I'm not going to go point by point over these good drafting practices. These are the do's. I am just going to emphasize a couple of them because some of them we've covered already. But this is a great checklist. And the next slide will have some of the don'ts. But this is a great checklist when you're maybe reviewing some of your independent contractor agreements yourself. We've already talked about contracting with an entity instead of an individual. The second one here, providing a description of the scope of services performed, that's very important. To show that there's not an overlap between the work that's performed by employees and the work that's performed by your independent contractors. The acknowledgement of no direction or control, we've certainly talked about that today. The fourth point here, requiring regular invoices from the independent contractor, that's an important point because you want to show that your independent contractors aren't paid hourly like your employees are, or aren't given a salary. They should be paid under a separate compensation model. And we typically recommend that clients require that the independent contractor invoices the nonprofit, say, within 30 days after services are performed, or another good benchmark might be the 15th of every month. Indemnification provisions here, candidly, this is less to beef up your classification, and it's more just to protect your organization. The independent contractor is an agent of his or her principal, and the principal is the nonprofit that engages the independent contractor. Your organization could be liable for the acts of the independent contractor. If the independent contractor hits a pedestrian while he or she's driving one of your organization's vehicles en route to one of your events, you could be your organization could be a co-defendant in that lawsuit. So it's important to have indemnification provisions. On a related note, require the independent contractor to obtain insurance. That gives your indemnification provisions some teeth. It makes it worth more than the paper it's just written on. Because if in that hit and run example I just mentioned, if it's just a single member LLC that you're engaging, they might not have assets to satisfy a judgment, and the nonprofit's still named as a co-defendant, your organization might be left holding the bag to try to satisfy a judgment by the injured plaintiff. The seventh bullet point here on this checklist is setting the length of the engagement and the conditions for renewal. It's really important to expressly lay out in the contract what's going to happen when the term of the engagement ends. The laws vary considerably state by state. In my home state, there are situations where the entire agreement can be automatically renewed depending upon some of the terms and conditions in the agreement if the parties just keep doing what they were doing. So that means if you had a 12-month contract, if in the 13th month the contractor keeps performing services, you could see a situation where that contract got automatically renewed for another 12 months. Of course, it would be subject to your termination provisions, but it's important to just agree in advance what's going to happen when the contract ends.
And there's many other non-employment related and for reasons outside the scope of this program, many other reasons to spell out exactly what happens when that agreement terminates, and everything from ownership of copyrights and trademarks to how they can describe their relationship with your organization, to so many other points.
And that's actually one of our next points here on this checklist, is protecting the ownership of inventions and confidential information. That's another area that varies considerably state by state in terms of the rules for enforcing those covenants. It's a particular area to make to consult with counsel on. You want to make sure that all the work product that's generated by the contractor in the course of the engagement is work product that's going to belong to your organization. The last two quickly here, really the second to last one, because we covered the mutual intent not to create an employment relationship. Describe your expense reimbursement requirements. It sounds trivial. It sounds like something you wouldn't need to do. But I've had a number of clients now where they terminate the independent contractor relationship, and maybe it didn't end under the best of circumstances. And then suddenly the independent contractor has all these receipts for all these expenses that were incurred months ago, and he or she's seeking reimbursement. A good industry standard, if you will, is just require receipts to be submitted within 30 days of the date on which the expense was incurred. Then you have a contractual basis for denying the expense reimbursement. So that's a quick run of the do's, and I'm just going to run through quickly of some of the don'ts for drafting. And a lot of this is consistent with some of the factors we've discussed already. Don't have a lot of requirements in your contract about when work has to be performed, where work has to be performed, the manner in which work is going to be performed. I do not recommend a vague description of services. Some clients want that. They say, well, we want broad discretion to basically tell the independent contractor to do whatever we want him or her to do. There's a give and take there, because not only then is it not a good exhibit for a defense about the classification issue, but then if there's a dispute between whether the independent contractor was really doing his or her job, if there's a contractual dispute there, you don't have a good document to rely upon that sets forth what you agreed the independent contractor would be doing. The next one here, requiring non-competition after the end of the engagement. We talked about how that's a factor that weighs against the proper classification. Inadequate notice of termination of the engagement. If the independent contractor is providing some really important services for your organization, you don't want to be left in a bind when the independent contractor just disappears suddenly and ends the relationship. You typically want 30 days, 60 days, maybe 90 days notice of when the contractor has decided to terminate the relationship. Whether your organization gives the contractor that same notice, whether that promise is mutual, that's a matter for negotiation with the contractor. We discussed paying the contractor on an hourly basis. That generally should not be the case. It's not dispositive, but it should not be the case. Go back to my house painter example. You would never pay the house painter based upon how long it took him or her to. This is bad because lawyers are paid by the hour. Maybe I shouldn't talk about it. No. You wouldn't pay your house painter, based upon how long it takes him or her to complete the project. The same should be your independent contractor. And lastly, contracting directly with the individual. I know we've covered this, but I do want to point out, it's okay sometimes to enter into a contract with the individual, but if he or she has an LLC or some type of other entity, push for the contract to be with that entity, because a judge or the Department of Labor will look at that and they'll say, well, that rings a little more true of a real arm's length transaction, a business transaction for services. And now I'm going to turn over to Doug to talk about some of those cases that Carl mentioned earlier.
So we picked the 4 cases that Carl talked about because we wanted to make certain points. They didn't involve nonprofits as defendants, but to be sure, your workers, and I use that term because you might think some of them are contractors and in fact they're employees, but anybody who's working for you can make the claims that the plaintiffs in those 4 cases made. anybody working for you conceivably can come in and try to get unemployment compensation or protection under the civil rights laws like Title VII. And a lot of people who work for you can claim minimum wage and overtime and can try to form a union if they're so inclined. So keeping that in mind, let's get back into the cases. A quick refresher on the exotic dancer case. You remember the facts of that case. They signed agreements. They said that we are independent contractors. The club didn't pay them. They got paid entirely by tips. The clubs set the dancer schedules. The clubs controlled the advertising and hours and music and lighting. And the clubs regulated their appearance, their apparel, their behavior, their ability to enter and leave the clubs, and their ability to have visits from family or friends. Right? So the dancers sued, and they said, we're employees. All those people who signed agreements saying they were independent contractors, they say, we're employees. And the clubs counterclaimed. Clubs said, well, these people were not employees, they're contractors. The clubs counterclaimed for breach of contract, unjust enrichment. And let me just tell you this. When you get sued in a case where you think it's nonsense, you're going to call me up and you're going to say, I got an idea. Let's counterclaim against those employees. Let's show them. And I'm going to give you a 2-word clue about what I'm going to say in response. Okay? Because I can't tell you how many times I've heard this over the years, and what I always do when the client goes into that rant about we're going to counterclaim is I wait and I say, are you finished? Have you got that off your chest? Good. The answer is no. We're not doing it because we're not going to give these plaintiffs an opportunity to say, you see what happens when you assert your rights? You see they're victimizing us all over again. Look, if somebody steals your trade secrets, if somebody destroys your property, yeah, we'll sue them. We're not counterclaiming in the ordinary course of business. Thank you very much. So what happened here, right? The court ruled for the plaintiffs. And this was largely about the degree of control that the club had over the manner in which the work was performed. Let's get to the important question here, which is, could the employer have done something different to change this outcome? Well, one thing that would occur to you is, what if we got them to sign a different agreement? Well, the court's decision tells us that the club owner had these dancers sign this agreement because years earlier, some dancers had sued the club and they said they were employees, not contractors. The club owner didn't like that. So he says, I'll fix them. We'll get them to sign this agreement that says they're independent contractors. Well, you can see how that turned out. The real issue here is what the court said the issue was, which was the degree of control the clubs exercised here over all aspects of the dancer's work and the club's operation argues in favor of an employment relationship. So if you're asking what could the employer have done differently to get a different outcome, to have these people called contractors, you have to ask what control would the employer have been willing to give up? These dancers were required to sign in upon arriving. They had to pay a tip-in fee just like the guests of the club did, right? The club dictated their work schedule, right? You have to ask yourself, we talk about the words that go into the agreement. Never mind the words. It's the substance of the relationship, as you've heard several of us already say. What would this club owner have been willing to do to change the substance of the relationship with these dancers to turn them into independent contractors? I think there are 3 morals of the story from this exotic dancer case, right? First is, but they agreed to be independent contractors. Almost everybody who's misclassified as an independent contractor started out agreeing to be an independent contractor. And in fact, as you know, probably from your own experience, many people insist on being independent contractors, which leads to the question, so how do they wind up suing about this? Because it's not that somebody walks in your office. It doesn't happen where somebody walks in your office and says, I've been thinking about this. And actually, I think I'm more like an employee than an independent contractor. I mean, has it ever happened? Sure. That's the very rare situation. I'll tell you what the common scenario is. The common scenario is this person says, yes, I want to be an independent contractor. We're all lovey-dovey at the beginning of the relationship. Then something goes bad, and now that person's talking to a lawyer. And that person says, those bastards did me in, I want to sue them. And the lawyer says, okay, let's figure out what we got here. Do you have a written employment agreement that guarantees you won't be fired except for gross misconduct? No. Okay. Then we start with the checklist of possible discrimination claims. Did they do this to you because you're a man, a woman, Latino, this religion, that age, right? They got nothing. And then the lawyer says, well, did they pay you overtime? The person says, well, I didn't get overtime. Why not? Well, they called me an independent contractor. Really? Well, did they tell you when to show up and when to leave? Yeah. Did they tell you what to wear and what not to wear? Yeah. Did they tell you when to perform and when? Yeah. And the lawyer says, independent contractor, forget it. You're an employee. Now we've got a claim. Where's all the overtime you should? All right. That's how it's going to come up. It's going to be the lawyer who thinks of it and puts it together based on the facts. Oh, no joke. No joke. This is how it works. Next, quickly, guess who filed an amicus brief in support of these plaintiffs? We got a bunch of exotic dancers suing, saying that they were employees. The Secretary of Labor in the Obama administration, because in the Obama administration, the Department of Labor thought that everyone was an employee, and this case was consistent with that. As Nick already mentioned, those tides have turned. Last week, the Trump administration withdrew DOL guidances that go in that direction. It remains to be seen how this will all shake out. Let me add quickly, third moral of the story, different dancers dance different dances, and you can get different results. There was a case, 2012, out of the federal court in Arkansas, where the employer of exotic dancers prevailed in showing that the dancers were contractors, because in that situation, the dancers had retained substantial control over what they did and how they did it and when they did it. And so the moral of the story here is it's like a lot of things we tell you about the Fair Labor Standards Act. It's not in the job titles. It's in the responsibilities that the employees have or don't have. Case number 2. Remember the yoga case. Quickly reviewing the facts. They had staff instructors, and then they had their non-staff instructors, and it was the non-staff instructors they called independent contractors. Remember, the studio set the fees, they charged the customers directly, the instructors chose, you can be paid hourly or a percentage of the fees, the studio set the hours, the licensing requirements, the class space, instructors signed up for different classes at different times, they were not required to attend staff meetings. Imagine a job where you don't have to attend meetings. This sounds like a great job to me. And the instructors could work or advertise for other studios. Now, Carl told you it got to the Court of Appeals in New York. Court of Appeals in New York is the highest court in the state. How did it get there? How many rulings do you think it took to decide this case? First, the Commissioner of Labor says these non-staff instructors are employees, and therefore Yoga Vida was liable for additional unemployment contributions. So that's the Commissioner of Labor. Yoga Vida doesn't like that result. You go to an administrative law judge who says, no, these non-staff instructors were contractors. End of story? Not so fast, because after the administrative law judge, it goes to the Unemployment Insurance Appeal Board, which overrules the ALJ and says the Commissioner of Labor got it right the first time. These non-staff instructors are employees. End of story? Of course not. We go to the appellate division. It's the Intermediate Appellate Court in New York. And the Intermediate Appellate Court affirms the Unemployment Insurance Appeal Board, says, despite the existence of evidence that could result in a contrary result, the record contains substantial evidence to support the board's decision that Yoga Vida had sufficient control over the instructors. Therefore, they could be employees. So surely that's the end of that, except it winds up going to the big court, the Court of Appeals, which says the record as a whole does not demonstrate that the employer exercises control. Therefore, the board's determination is unsupported by substantial evidence. The non-staff were paid only if a certain number of students attend. There were no restrictions on where non-staff could teach, right? That's the majority. These people were, these people were in fact, I lost it, employees. But we get a vigorous dissent in the case. The dissent says, yeah, there's lots of evidence to support the view that the non-staff instructors are employees, but a little bit of legal stuff here I want you to know. The majority has examined the evidence before the board, says the evidence weighs more heavily in favor of a conclusion that these were independent contractors, but it's the role of the board, however, and not this court, to weigh the factual evidence and arrive at a conclusion. If the evidence reasonably supports the board's choice, we may not interpose our judgment to reach a contrary conclusion. Welcome to the world of court review of agency findings, right? What the dissent was saying is, it's not our job to decide are they contractors or employees. It's the court's job to decide whether there was a legitimate basis for the agency to decide are they employees or contractors. This shows the importance of helping the agency as the defendant, helping the agency get it right the first time. We'll say a little more about that in a minute. Third case, the orchestra case. Right, you remember quickly the facts. The musicians go to the NLRB. They say, we're employees. We want to form a union. The orchestra says, don't be ridiculous. They're contractors. Remember the undisputed facts. There was a series of programs. Each one of them had 4 concerts. The orchestra sends a bunch of packets to invite the musicians. They're paid by the rehearsal or the concert. There's no withholding from their paycheck. The agreement with the musicians calls them contractors, and there's a whole etiquette about what you have to wear and how you have to act during a rehearsal and during a performance. It's a good thing law firms don't have etiquette requirements. Some of us would have had shorter careers. The musicians, the union, files a petition for certification as a union, and the orchestra opposes it. Let's see how many decisions had to be made before we got to the finish line here. First, the regional director of the NLRB says these people are contractors. You say, what? Somebody associated with the National Labor Relations Board found that these workers were contractors? Talk about a tilted playing field. NLRB is always finding people are employees, but here the regional director says they're contractors. Now the issue goes to the NLRB, the board itself, who says, what? Are you kidding? Contractors, don't be ridiculous. These people are employees. Why? Well, because the orchestra has substantial control over these musicians. The musicians work as part of the orchestra's regular business, so they hold an election, the union wins, and that's that. It then goes on appeal to the D.C. Circuit Court of Appeals. There are 10 factors, a whole bunch of analysis, and the D.C. Circuit says, because of the circumstances of this case, and look, there are 2 reasonable alternatives here. They might be contractors, they might be employees, and the D.C. Circuit says we must defer to the board's conclusion that the orchestra's musicians are employees. The D.C. Circuit did what the dissent in the last case was talking about. Not for the court to decide employees versus contractors where the agency has made a decision. We're going to defer to the agency if there's any reasonable basis for that. And the D.C. Circuit actually said this case is not like this case from 10 years earlier in Minnesota involving a Minnesota orchestra where 2 musicians had sued saying we're covered by the Americans with Disabilities Act and Title VII because we are employees. Remember, only employees are covered by the civil rights statutes. And the court said, look, not everybody who follows a conductor or a leader is an employee. Right? And the court says, you know, the notion that everybody who follows when the conductor goes is an employee, that would make every musician in every orchestra an employee. That's ridiculous, right? So the D.C. Circuit says we're not like that case. And what's the difference? Well, in that case, claims under the civil rights statutes, the court is deciding for itself, is somebody an employee or a contractor? But here, we're not doing that. We're just deciding whether the NLRB had a legitimate basis for concluding as it did. Next question. In this orchestra case, could the orchestra have done anything to change this outcome? The answer is, I don't think so. Right? This is a situation where the structure of the relationship is what it is. This conductor is going to get up, the employees are going to, the musicians are going to follow, and if somebody thinks that that makes every musician an employee, that's tough.
Doug, let me interrupt you for a second. I know we're short on time, but an important point here, all the cases so far that you've talked about have principally focused on the level of control by the employer over the workers, and that is obviously the #1 area of focus. But another issue, one of the factors that comes into play quite often is the issue of, does that worker work for other clients? Do they have a business where they do, or could be a musician that works for other orchestras? And so they're doing it on a part-time basis for the one employer, but they're also working for other clients, or other employers during the course of the year. How does that factor into the analysis, and how could that have factored into the disposition of this orchestra case?
I think that's a significant factor that we regularly ask our clients right up front, because somebody who is performing similar services for other organizations, I think that's a key factor in being able to say we don't have the kind of control over that person that we would have over an employee. Literally, they're doing other things with their working hours that have nothing to do with us. So it's a first cousin to the control issue. And I would think in the orchestra situation, the ability to say these musicians work for us, like this piece of the year, and for the rest of the year, they're doing so many other things that we have no control over, have nothing to do with us. I think that's a compelling argument that those musicians are independent contractors, much as it's a very good argument for you when you've got people doing some things for you, but they are free to do lots of other things for others.
But of course, we wouldn't be good lawyers if we didn't say just being part-time doesn't automatically guarantee contract status.
That is the flip side of that. Correct.
Doug, just one really important caveat to the non-exclusivity. I know we're short on time, but it's true that non-exclusivity is a very important factor weighing in favor of the independent contractor classification. But one really important caveat to that is a conflict of interest provision in your agreements. If your independent contractor has access to sensitive information, trade secrets, confidential information, it doesn't mean that you can't prohibit some limited type of engagement so that the contractor isn't maybe working, simultaneously performing work for someone who has an adverse interest. So it's something to keep in mind.
Let me give question in the back.
Wait, Peter, just wait for the mic. Hold on.
Thank you. It's a pedestrian question, and I apologize, but I suspect that everybody in this room at one point or another has had a staffing firm that plugs in a person because a person is needed for a day, a week, a month, or 6 months. And what is the takeaway here as to the reason, purpose, and frankly value of using a staffing firm for that purpose other than simple efficiency of finding the right person? In other words, does using a staffing firm for that purpose, even if you have the right provisions in the agreement, so to speak, really change the relationship? Are you a joint employer if that person is being plugged in to sit in a chair doing the kind of thing that an employee was doing next to other employees doing roughly the same thing, using an organizational email address, et cetera?
And Doug, I'll let you answer, but just as a predicate, this was the issue we were talking about earlier, that in this situation, if somebody gets a big staffing firm, lots of employees, they're plugging someone in for a 6-month period, say full-time, part-time, regardless. If in a situation where that company provides services to lots of other employers as well, we're likely not looking at an independent contractor situation, but we very likely are potentially looking at a joint employer situation.
Yeah, that's exactly the point. So I start by saying if you need an outside staffing agency, I wouldn't let this issue drive that decision, but we want you to do it with your eyes open. So it's not a question of whether the person from the staffing agency who's sitting next to one of your employees and they are virtually indistinguishable in what they do, that's fine in that context. The question then is that they're not going to be an independent contractor. The question is, are you a joint employer? And that's going to depend on the nature of the relationship. You may well be, and you need to have your eyes open to that. We don't want you to assume that you're not going to have that liability simply because you've contracted with an outside agency. I'm going to essentially skip over the last case because I want to get to some quick summary comments. But the last case was the blogger who ultimately, after numerous agency determinations and court rulings, was determined to be an independent contractor. And we made that case the last one because we wanted to give you some consolation that sometimes these things actually turn out the way that you think they should. So what are the overall morals to these stories? Number one, right? All of this stuff applies to all of you. Okay, let's be clear about that. Just because the cases didn't involve nonprofits doesn't mean anything. It's frequently going to involve a number of your workers. And as I said before, everybody who works for you is going to have some claim or another where they can focus on the issue of we were actually employees, not independent contractors. So this stuff applies to you. Secondly, it cannot be said too emphatically the playing field is tilted against you to the extent your desire is to classify people as contractors. And partially that's true because, as you've seen now, frequently these issues will wind up before an agency first, the NLRB, the Unemployment Compensation Board, and these agencies, the playing field is really tilted in favor of them concluding that people are employees as opposed to contractors. These winds may shift with the new administration, but let's see what happens. Nothing changes dramatically quickly on this front. Next, you've heard a lot of talk about documenting and do's and don'ts. Right? Documenting this contractor relationship is necessary, but it is far from sufficient. It doesn't matter what the title is. It doesn't matter that the person agreed to be a contractor, as you saw in the cases we showed you. You know, the dancers agreed to be contractors. That didn't matter. It's about the substance of the relationship. So lastly, I like to put it to clients like this. Right? If an outside observer were to observe your contractor and your employee working in your workplace, would they be able to tell the difference? Right? If so, if they could tell the difference, that's helpful, but it isn't even a dispositive. But if they can't tell the difference, well, that's not necessarily fatal, but it suggests that you're going to have a problem. Want to allow for a few minutes here at the end for some more questions. Jeff has tipped me off that we were getting questions about interns. How many of you
and other volunteers?
And volunteers. How many of you have unpaid interns in your offices this summer? Good.
And how many have paid interns?
All right.
Then an equal. Well, and I think we've set up our next employment topic to cover maybe in the fall, which we covered in the past, involving interns and volunteers in this context. But why don't you very briefly touch on these issues?
Yeah. So those of you with the unpaid interns, we've got plenty of business cards up front, and we look forward to speaking with you probably in the fall.
Yeah, there largely is not much world left for unpaid interns, and with very limited exceptions, usually involving college credit. But
yeah, they have to be programs of an educational nature, and quickly the analysis goes like, who's getting the benefit here? You know, if the benefit is to the intern, that they're learning something they wouldn't otherwise learn, there's some structure to that program. Best of all worlds, when they're getting actual academic credit from their college, university, perhaps even high school. Those are the situations where we've got a decent chance of being able to say this is a legitimate internship, as opposed to what the Department of Labor is inclined to think about all these things, and the EEOC, which is these people are actually employees. How do we know? Well, because they are doing the work that would otherwise be done by an employee. That's the key thing. Is there some expectation of a job at the end of this internship? If so, that's going to look like an employment relationship, because you don't get to hire people for free to try them out to see if they can learn enough to become employees. So,
and by the way, once they finish their internship, in many states, as you guys well know, they can file for unemployment compensation and will generally get it.
So with respect to volunteers, you folks at least have the advantage over the for-profits, because for-profits can't have volunteers. Nonprofits can. But again, the authorities will look to the substance of the relationship, because if it looks more like somebody who's just doing an employee's job and not getting paid for it, that's going to be regarded as employment. Then you have fun issues about when your employees want to volunteer for other tasks in your organization. And the answer is sometimes that's okay, but if it looks like an extension of their job for you, then that's going to be trouble.
All right. Thank you, Doug. A couple things I wanted to point out. In your handout materials, and those of you on the webinar will get this sent to you tomorrow, there is an article that we just released yesterday on the new Trump administration guidance, withdrawal of Obama-era guidance on independent contractors and joint employers. And there's also 2 documents from the U.S. Department of Labor's Wage and Hour Division on these issues, although these are certainly potentially subject to change. I want to thank our speakers for a terrific program today. Thanks for all of you for participating. Hope you enjoy your summer and will join us back here or on the webinar in September. Thanks very much.
Thanks, Ed.
Good afternoon. Welcome to our program today entitled An Independent Contractor, an Employee, and Their Attorney Walk into a Bar, Why This Is No Joke for a Nonprofit. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. And this program, as many of you know, is part of the monthly series of programs that we do here in Venable's new D.C. offices on a wide variety of different nonprofit legal issues. We have a packed room here of over 100 people joining us for lunch in our Washington, D.C. offices today. And we have over 400 people joining us on the webinar across the country today. So one of our highest numbers of